Welcome to the In Early podcast, where I speak to those at the forefront of the digital assets and technology sectors, telling real-life stories, considering the growth and growing pains of the industry, and exploring how blockchain and other technology has made an impact on people's lives. My name is Matt Green, and I head up blockchain, digital assets, and technology disputes at law firm Lawrence Stevens. This week, I speak to Professor Sarah Green, who just finished a 4-year tenure as the Law Commissioner for Commercial and Common Law, predominantly dealing with all things digital, including drafting various iterations of the Law Commission's paper on digital assets. We speak about the journey of crypto assets becoming property of common law and why that was important, to where we are now, with legislation looking to define things as property, using a negative definition proposed by the Judiciary. Sarah is now the head of digital assets at trade finance at D2 Legal Technology and a professor of law at Bristol University. I really hope you enjoy this episode. Sarah, welcome.
Hi, it's nice to be here.
Thanks very much. Let's get stuck into it. So your About page on LinkedIn is absolutely not messing around. It says, and I quote, Professor Sarah Green was Law Commissioner for Common and Commercial Law at the Law Commission of England and Wales from 2020 to 2024. During that time, her law reform work included the Electronic Trade Documents Act 2023, advice to the government on smart contracts, updating the Arbitration Act of 1996, scoping reforms to the law of Intermediated Securities. Did I say that right? Yeah, just about. And drafting guidance and a bill to ensure that English law is well suited to accommodate digital assets. Hopefully I got most of that right. In short, how did you get to that point in your life where you're doing all these things?
Well, as an academic, most of those things I had written about for the best part of 20 years, which is pretty scary looking back on it now. But I started life as a software developer at Accenture and then went back to law. I did a law degree, went to Accenture, then went back to law. So I had a natural interest in the way that the law interacts with technology. So I'd been writing for a while about how the law was going to have to change, or I thought the law was going to have to change to accommodate technological developments. And then at about the same time, the Law Commission and the government were looking for people to talk about that and to make law reform, along those lines. And so the job came up at just the right time. There aren't that many private lawyers who were interested in the technology side of things. They tended to want to ignore it. So I got the job, and it was a dream job at a dream time, really, because it was huge. 2020, so just before COVID and lockdown, which actually, although that was horrendous in many, many ways, it really helped us get the government to give us funding for a lot of the projects you've just mentioned, because they realised that actually, with the physical restrictions, with not being able to see people and hand over documents or, use conventional assets because people just had to stay away from one another, it actually meant that we could make our case for why the law needed to keep up with digital transactions and electronic documents. It made that a lot easier. So it was a silver lining to the whole code.
It was an easier sell.
It was
you need to be online, right?
Digital. Yeah, much easier.
And for the sake of those who don't know, and again, I always mention my dad on this, but for the sake of maybe my dad, let's run through a couple of those or a few. Can you summarise what work you did on the Electronic Trade Documents Act 2023 for starters?
Yeah, absolutely. So that is my baby. So that's the thing that I've been...
Your face is lit up.
Yeah. It's something that I'd been writing about since 2005, I think. So
this is a long
project, yeah. Because it became clear to me, as I said, with my technological background, I realised that the law as it stood wasn't going to be able to accommodate what commercial parties wanted to start using, which is electronic documents. Now, I know people will be thinking, well, everybody uses electronic documents. I send Word documents, I send PDFs all the time. We don't, what's the big legal fuss? But the point is, and this is the boring lawyer's law bit, well, it's not boring to me, but it's absolutely essential to understand why we needed that act, is that legally there are certain documents that had, before that act, to be in physical form. Why is that? Because the law required them to be held and transferred and possessed in order to work. So you get these documents when you sell goods. There's these documents, for instance, called bills of lading, which are documents which represent, for instance, goods on a ship. And if you've got that document in your hand, it's incredibly valuable because there is a sort of legal alchemy that occurs, which gives you, by virtue of holding the document, you thereby have right to the goods, which is, of course, huge commercially. But that explains why those documents had to be in physical form before, because they had to be possessed and held and transferred.
To be able to wave it around at that point.
Yeah.
Right.
And so that when I have it and give it to you, I no longer have it, and you have it, and you have sole control of it, and you have the sole copy. Well, you have the legally relevant sole copy of it.
Yeah.
And you couldn't do that in digital form. The law just wouldn't allow it. So parties wanted to use, for obvious reasons, electronic bills of lading, because with paper, you actually have to get that piece of paper from, maybe I'm a seller in New Zealand and you're the buyer and you're over here in England. You'd have to wait for that physical paper document to get from one side of the planet to the other, which is, of course, in 2023, absolutely crazy.
Yeah.
So the Electronic Trade Documents Act, all 6 substantive sections of it, is really just about making legal equivalence between paper documents and electronic documents that fulfill certain criteria. That's the important thing, because those electronic documents have to be able to do what you and I have just said. You have to have a singular copy, has to be fully transferable, so that when I get rid of it, you don't want multiple copies around. It's the double spend problem. I don't want to give you right to those goods and give it to 10 other people as well.
Where were you in the music industry when people were copying music?
Exactly.
Napster, where were you then?
Yeah, so the technology is only quite recently able to do that. So that's what that act does.
I'm going to move on a little bit because I'm interested in that, but I'm aware that we have so many questions to get through. But let's have a quick chat about your government advice on smart contracts. What was some of the work that you did there?
Yeah, so smart contracts were obviously, they when we started this project in 2020, they were sort of fairly nascent. And in fact, a lot of contract lawyers didn't like to think about them at all. But I think now that they're really quite mainstream. And when we started that project, we did it with a view to maybe reforming the law of contracts so that it could deal with smart contracts. And interestingly, about halfway through, so the reason that's called an advice to government rather than it being a bill or an act or anything, is that halfway through that project we realised, and at the Law Commission I should say we consult very widely, so we'll talk to lawyers, we'll talk to technologists, we talk to end users, everyone. We realised that actually contract law wasn't a problem. So the rules of contract law as they stand and as they have stood for centuries are absolutely fine. It's not the rules that needed to change, it's the way in which those rules are applied in electronic and digital form. So for instance, very basically, for a contract, you need an offer, you need an acceptance, that's trite law. You need some other things as well, but let's stick to offer and acceptance. And the thing is, of course, you can have an offer and acceptance. You're still going to need that with a smart contract. It might look a bit different because it won't be me saying to you, Matt, do you want to buy my oats for, whatever, £50 a tonne? It's quite cheap, whatever.
That's
oats. Your
example.
Oats. Yeah, because that's what the contract case is about. They're about oats on the sea. But for smart contracts, it would be software I had programmed, for instance, interacting with software you had programmed. But I would have programmed it to make an offer and you would have programmed it to accept on certain terms. So, the rules and the legal shape of that agreement is exactly the same. It was really then we realised it was about educating lawyers to apply the old rules to the new system.
So it was almost about putting the old rules onto a new mechanism that was digitised.
Yeah, absolutely, yeah.
And now let's turn to where our paths cross broadly, right? So which is the treatment of digital assets, and which started with, and I'm going to run through chronologically all of the different things that you've done. Started with the publication of the UK Jurisdictional Task Force's legal status on crypto assets and smart contracts all the way back in 18th of November 2019.
I do just have to say that wasn't me.
I thought it was you. Your name was on it.
I was an observer on it, but I can't claim credit. A lot of the work was done before I was on board, but you're right, I am now on UKDT, and I did do comments on that.
When I was Googling it, I swear it said something. I saw your name on it somewhere. Maybe you're a contributor.
I am on you. I did contribute,
well, there you go.
But I can't claim that was my work, is all I'm saying.
Okay. So we had the legal statement, and we had the legal statement on crypto assets, smart contracts, and which concluded that there should be, in theory, no bar to crypto assets being property at law. And for smart contracts to be legally binding all the way back in 2019, to which you were, I think I put here, specialist consultee.
Oh, well, that's probably about right.
Probably
yeah,
right.
Yeah.
So can you tell us broadly what property is and why digital assets didn't fit into any of those. And I should have warned you before the podcast. I put some definitions on if that's helpful to refer to.
Yeah, okay. So why is property an issue in terms of digital assets? I mean, the electronic trade documents that I've just talked about are really a subset of this, and we would have done them all together if resources had let us. So it goes along similar lines. The problem with digital assets is that for a very, very long time, English law, well, and to some extent, I should say, still does. So it divided personal property. So personal property is everything that isn't your land, really, or things, buildings and land. Divided that into two categories, known as things in action and things in possession. And those categories were regarded as completely exhaustive, so that if you didn't get a thing in one of those two categories, it couldn't be the subject of, or the object, I should say, of property rights.
Can we just put an example in? So if it was something tangible, rather, and that's possession, or chose a right, like a contractual right to do something, right? Those are examples of those two.
Yeah, so that's a really important distinction. So things in possession, or historically shows in possession, are everything that you would imagine. So your watch or your laptop, or if you look at the historical cases, bags of gold. Things that you can touch, and again, to go back to the thing we said about documents, things that I can hold, I can pass on to you, I no longer have it, it's very obviously a transfer, and that's things in possession, that's fine. Now, things in action are complete intangibles. So things, the obvious one is a debt. Everybody knows what a debt is, I think. And the point about those pure intangibles is that they don't have this existence in the world like a piece of paper or a watch. All that they are creatures of the legal system. So they only exist insofar as you've got people who claim them and a legal system that recognises them. They're hugely important, but there is a massive difference between those and things in possession. So historically, the law said it's one or the other. And then, of course, digital assets come along, and they are, well, I think they're much closer to things in possession, because I can have, say, an NFT, just to be really generic and sort of quite future-proof, right? Some sort of non-fungible token, whatever it amounts to, that has an existence in the world. So it's not like a debt, because if you or I didn't claim it, nobody claimed it, and a legal system chose not to recognise it, it would still be there.
So
that
it exists
NFT,
outside
exactly.
of the legal system.
Yeah.
This exists objectively.
Exactly. It has an independent existence. But, so you would think, things in possession, which actually I think that would do. But I can understand why there was difficulty with people accepting that it was a perfect thing in possession, because, for instance, some of them are transferred in different ways. So if I give you my watch, what leaves my hand is exactly what arrives in your hand. And of course, with some digital assets, that's not the case. They might be extinguished and transferred and recreated in, say, your wallet. So there are lots of reasons why they're not quite things in possession, but they're definitely not things in action, I don't think. That was the Law Commission report, because they have this objective existence that you've just pointed out. So that was the problem. We have these assets that people were using, people were spending millions on them, not realising at that point that if something happened to them, we all know that if we've got a laptop and someone takes it from us, we know that we've got legal protection. And we're right in this jurisdiction anyway. But people were investing all this money in digital assets. And the question, as I said, to some extent is still open. Is their property right in that going to be protected? And that has not been clear at all. So that was the focus of my work on digital assets.
And what right does declaring something property give an individual?
Yeah, so if you have a property, it means that you it's protected against the world, basically. So that if somebody takes it away from you, sort of interferes with your possession, this is why it matters what the sort of nature of it, then you have legal remedies. I've heard people say you can get your thing back. The peculiarity of English law is you don't necessarily do that, but you could get, you might get the thing back, but it's it's judicial discretion, but you would certainly have your right protected in another way. So say you'd get damages that amount to the market value of that thing. But it's really about protecting it against third-party interference.
Okay.
And without a property right, you don't have that.
Yeah, I think it's about having a almost like a title to something, but it also just gives confidence in that asset to a wider market, right? Because if something is declared as property or treated as property, then there is a sense that a market will treat it differently because there is an ownership status.
Absolutely.
That's how I saw it.
Absolutely. And very importantly, in situations of insolvency, nobody likes to think about this because they don't imagine they're ever going to be insolvent. But in situations of insolvency, if you are holding something and I have a proprietary right in it and you go insolvent, if I have that proprietary right in it, so say you're a custodian of something, I will be a secured creditor in your insolvency, which means I'm very likely to get my stuff back. Whereas if all I have is a contractual right, I don't have a property right, I've just given it to you and we have a contract, you're looking after it, I'll be an unsecured creditor, which means I rank far lower when the assets are being distributed, and that's really bad news. So a property right gives you a strong claim, a much stronger
claim than you might otherwise have. When I was looking through the legal statement on crypto assets and smart contracts from 2019, paragraph 31, it notes, and I quote, "We can therefore identify the principal, novel and characterized features of crypto assets as being intangibility, cryptographic authentication, use of distributed ledger technology, decentralization, and rule by consensus." Now, end quote. And that was 2019. And when I think about where we are now, I would question the decentralization part, mainly because I don't feel like there's always a need to be decentralized. You have sort of crypto assets like Tether and USDC, where there is clearly a centralized entity behind it. I appreciate this was in 2019, but do you agree with my observation? Do you have any observations on any of those 5 points? Is that still correct, or do you think we've moved on?
No, I think we've moved on. So the difference between the UKJT and the Law Commission is that the UKJT is there to state, as the name suggests, it was a statement of the law, whereas, of course, the Law Commission has greater power in that it changes the law. So they're doing slightly different things. And what we realised at the Law Commission is that I think for digital assets, to identify that subset that can then be the object of property rights, you need to be a bit finer grained and you need to be a bit more discerning, really. So what we decided to do, the Law Commission, in identifying digital assets that could be the object of property rights, is rather than identify them in terms of putting them in boxes like a cryptocurrency or a non-fungible token or a real-world asset representation, we thought, well, we won't do that because who knows what digital assets are going to evolve over the next 10 years. Exactly. Right? So what we did is we went to what we thought were the sort of the purest, sort of rawest principles of a digital asset. And so it does overlap with what you've read from the UKJT statement. But as I said, it's a lot narrower, and we have moved on.
Yeah, I think so.
And so what we said was independence, which is, of course, what we've talked about already several times, because that's super important. Something has an objective existence in the world. And then a word which I'm not wild about, but we could never think of a better one, and we asked loads of consultees and neither could they, which is rivalrousness, which is simply that if I have something, if I'm enjoying something as a piece of property, that you can't do so at the same time.
There's an exclusive use of it.
Exactly.
I'm going to come on to all of
all
this.
Right, okay, right. So yeah, I think we've moved on to those two things.
Yeah, I think that's broadly right. Looking at it, it was quite nice reading those criteria, but it seems like we've moved on. Now, through a Crypto Mondays event organised by Brian Mundo, I met Dr. Keir Finlow-Bates, who in turn spoke very knowledgeably about the fundamentals of blockchain. One thing he hadn't realised was the issue around crypto assets being property, as we've discussed. And I explained to him the issues around defining property at law, things that are tangible and rights that aren't, things that you have a contractual right to. And that pre-2019, this hadn't really been considered. He thought it was a bit weird. I talked him through the task force paper as we discussed and walked him through the case of AA Persons Unknown, which I was a part of. And in that case, an insurer sought a proprietary injunction over Bitcoin as a ransom paid, and the court had to grapple with, could crypto assets fall under a proprietary injunction on the basis that, is it property? It was the first time crypto assets at law had been regarded as property in common law, and it was a huge effort from the barrister at the time and the wider team. But yeah, Darryl Connell did a great job. In your view then, why hadn't this issue around crypto assets being property been considered pre-2019 when Bitcoin, let's just say, was broadly released a decade before?
I think there's a couple of things. I mean, I think the simplest explanation is that Bitcoin was Bitcoin obviously gets a really bad press, I think, generally, and people roll their eyes and it's seen as a very nefarious thing, and it can be, of course, but then, so can cash. So can the internet. But what it has done is it has spawned so much else. And, it's really, in terms of distributed ledger technology, in terms of getting around the double spend problem in digital form, that's all great. But of course, what it did come from was an anarchic, source, really. And the original ethos to it was, we can do this without intermediaries. We don't need banks. We don't need courts. We don't need legal advisors. Code is law, all that sort of stuff. So I think that probably for a while, and of course I'm not saying this as a lawyer, I'm saying this as a human stating fact. Of course, that is fine as long as parties are happy for it to be resolved in that way. But of course, as is inevitable, all of these things, once they spread into the mainstream, I mean, it's difficult to think of it not being mainstream now, but it wasn't then. And I think it was just, the availability heuristic of litigation, if you like, that it took that long for a dispute that parties wanted intervention with to get to court. I mean, I think it's that boring an explanation.
So I guess it took 10 years from its release to being widely adopted to being worth litigating over.
Yeah, I think so.
Like quite a short period of time, actually.
And it's increasing, isn't it? I mean, when we started this project in 2020, or these projects, I should say, a lot of what we were talking about, felt very speculative. People didn't really know, a lot of people didn't really know, especially lawyers didn't really know what it was we were talking about. If you fast forward even 2.5 years, most of our audiences had an idea what we were talking about. Yeah. And as you know, there has now been a suite of common law decisions after AA. I mean, that was, that was what I suppose you could say started it all, really. But there's been loads of judicial decision making now. So it does feel a bit sort of like a snowball effect, which is no bad thing in terms of sorting out what the rights are.
Yeah, it's been great. I think our jurisdiction's been leading the way with this sort of stuff. Just to turn, paragraph 59 of that judgment, AA Persons Unknown, the judge notes, with reference to the statement on crypto assets and smart contracts, and I quote, the conclusion was expressed was that a crypto asset might not be a thing in action on a narrow definition of that term, but that does not mean that it cannot be treated as property. Essentially, and for the reasons identified in that legal statement, I consider that a crypto asset such as Bitcoin are property, end quote. So at this moment, crypto assets were property, albeit at common law. I suppose the Law Commission saw this and thought, well, we need to do some future-proofing and consider it broadly. Was that the modus operandi for the Law Commission?
I think we just really wanted to bring some clarity to the law because, of course, the problem with common law development, which we just talked about, which is great in the sense that it is very responsive and it's a lot more agile, obviously, than statute law. Once you put something in statute, it takes years and years to change it, if indeed you can. But, of course, the downside to leaving it to develop through common law, through case law, is, again, you have to wait for the right case to come up. And, of course, what you then have as well most of the time, and I think this has played out and it's fairly true for all the cases we have had, is the question gets asked in small parts. Of course, in AA, it was about, could it be the subject of an injunction? And then you have, can it be, do you have a fiduciary duty in relation to, all these questions, separate legal questions, whereas we spoke to judges and we spoke to legal advisors, and we got the impression that what would be really helpful is a bringing together of all of those questions and all of those issues into one document so that we could deal with them all as a coherent whole. And I can't quite remember the time frame now. I think that we'd already decided that before AA was handed down. But the aim was very much to bring all of those issues together and to decide them as a coherent whole, which of course is something that judges can't do because they just have to deal with the question in front of them.
Absolutely. Yeah. Well, let's move through this chronologically then. There was the Law Commission's digital assets call to evidence. Can you tell us, I suppose you've already answered my first question, why was that set up? But secondly, who responded and what was some of your favourite or least favourite feedback?
Okay, so who responded? Really broad, as I said, and that's great. That's what we wanted. So we listen, technically, absolutely anybody can respond. We don't limit it.
And their name appears, I think, in the back of it.
Yeah, everybody.
Just get your name checked.
Yeah, it's great. So it tended to be really with digital assets. It tended to be either end users or technologists of some form, whether they were platform developers, service providers, their legal counsel, academics who were interested, judges. I think that probably covers most of the broad bases. So those were all the people. We got a huge amount of input from legal counsel, which was brilliant because we kept being told, you're looking for a problem.
Is that what they said, really? Is that the feedback, looking for a problem?
Loads of people told us that. No, before this, people would say to me, you're doing this project and it's only because it's hyped. And
was hyped for a reason, right?
Yeah.
But even when you go on LinkedIn now, anybody that touches any of this is always excited about it and promoting it. So
yeah, and there are real clients with real problems arising from this. So what was some call for evidence? Well, that answers the question about what was my favourite, really. It was just the really strong, yes, we're really glad you're doing this because these are questions that we have been asked for a while now. And of course, it's really hard to give legal advice when you've got no frame of reference and you have very little litigation, and there's the statutes need interpreting and it's not at all clear. So I could well understand why legal advisors felt like they really needed this. So that I think was my favourite part of the initial response, which was we're not just doing something that's science fiction and space age, and I've had all those things quoted at me, and so but that's my least favourite. I think was still a few people saying,
needless criticism.
Yeah, this is just the Law Commission wasting time when there are other areas of law that need reform. I mean, there's always areas of law that need reform, but so that was my least favourite.
Okay.
And it's still going.
It just seems surprising that there'd be such a pushback to say that this is a waste of time. But anyway, that was proved wrong. You were proved right. Next in the chronology was the Digital Assets Consultation Paper published 28th of July 2022, which included the Law Commission's thoughts thoughts following the assimilation of opinions provided under the call for evidence. Most notably, for me at least, was the issue around a proposed third category of property called data objects, which at paragraph 510 was proposed to exist where a thing, and I quote, is comprised of data represented in an electronic medium, including in the form of computer code, electronic, digital, or analog signals. 2, exists independently of persons and exists independently of the legal system. And 3, is rivalrous, end quote, to use your favourite word. Now, the first of these 3 limbs seems to my mind relatively straightforward, but there were a few points that I thought was worth fleshing out in the podcast. There is a statement within when I read it, which was an excellent footnote, which reads as follows, and I quote, "Whilst we consider that all tangible things have an informational attribute to them, we do not consider them to be composed of data represented in an electronic medium in any normal sense," end quote. The footnote reads, "This would come close to a fantasy or a Matrix-esque environment where all things were simply treated as being composed of information. See The Matrix 1999, end quote." Why was this something that was included? I mean, did you feel like there are extreme pedants at play? I mean, I know you have to go to the extreme to figure out what the boundaries are, but I laughed when I read this. Like, is that how far you needed to go?
Yes. This is an argument that we've heard, I heard for years when I was writing about this stuff academically, and has persisted, albeit generally from one source, really. And
from one source?
Well, one source, not one individual, but I mean, basically it's quite a strong academic argument, right? So
everything is data.
That all we're talking about when we talk about digital assets is information. And for anyone who's listening to this to whom it isn't clear, there is, and it's absolutely correct, that there is a legal rule that you can't have a property right in pure information. And there's a famous case, somebody stole an exam paper back in the days when they were all in paper, and copied down the questions, or remembered the questions. I can't remember the exact facts, but got the questions right, then put the paper back. And there was a big question about had he stolen that information. And it was like, no, you can't steal information because it is purely intangible. You can't carry it away. Obviously, if I've got information in my brain, I tell you this information, but it doesn't remove it from my brain. So that there's no independence of the sort that we've talked about. So there was a common objection to what we were trying to do with digital assets, which was, but they're just information. And you can't have property in information, which, as I said, I think is right. So we have been at pains to point out why they're far more than information. Because they are information instantiated in this independent, well, I think it's physical, but I don't think it matters whether you think it's physical or not. It's this independent form in the world. And the example I often give when I'm trying to explain this to the skeptics is to say that it's just information is the same as saying that, say I memorize the serial number of the notes in your wallet, should you have any. I've never got any notes anymore, but say you do, right? I memorize the serial number on all the notes in your wallet. And obviously, I then don't get the transactional spending power of those notes simply by knowing the serial. I need that note and I need to pass that note over. So it has to be instantiated in that form. And exactly the same is true of, say, a Bitcoin. I'll use a Bitcoin just because it's the thing that most people have heard of. So if you take a virtual currency that is in essence, if you put it in human readable form, it's just a string of it's like an alphanumeric code, right? Again, I could memorize or write down or whatever the alphanumeric code all the alphanumeric codes belonging to some, crypto whale. But I still wouldn't be rich. I wouldn't be any richer than I was before I did that, because just knowing that pure information is not the same as having the digital asset. It is not just information. It is information instantiated within a system.
So then you can't have proprietary rights over property.
Over information.
Over information.
Yeah.
Sorry, I completely screwed that question up. What I meant to say was you cannot have proprietary rights over data/information.
Exactly. If it's just pure information. So if I just tell you an idea,
then you're going to, and again, then all of a sudden you have database rights, copyright.
You have intellectual property, which is a completely different thing. But the whole reason why the law has intellectual property is that you can't have normal property rights in pure information or in a design or in an idea. So the law created this whole new statutory intellectual property right, which gave you the ability to an extent to protect your ideas. But that doesn't exist normally at law, which is exactly why statute had to emerge to protect it. And so a lot of people, again, in the early days said to me, and to some extent still do, oh, but, why can't you do it through intellectual property? But the two things are very different. So nobody says to you, if you buy a paperback novel, right, when you buy that paperback novel, you're not buying the intellectual property. You're not interested in the intellectual property.
That would undermine intellectual property rights, copyrights, if you did buy.
Exactly. You don't want it. You just want the book to read. Mm-hmm. And so when you buy, again, I'll use an NFT for the sake of being generic. When you buy an NFT, you don't necessarily want it because you don't want the intellectual property rights. You don't want to have it as your thing commercially to exploit. You want it because you want the border. I know I'm sounding, this is outdated now, isn't it? But, you want the artwork or whatever it represents. You want the thing, you want the use value. And the thing is, when we buy tangible things like books, and back in the day, if you bought a DVD, you knew you weren't buying the intellectual property and you didn't want the intellectual property.
You just want to be able to watch a movie.
Exactly. Right. And for some reason, when it comes to digital form, people merge the two and they can't see that, yes, you can have intellectual property in digital assets, but you can also have the use value, which is what you want.
And as to and again, we could talk about that for a long time, but that does answer the matrix question when you think about that. But certainly as to the second limb, about the data object existing outside of the legal system, existing independently from persons or the legal system. Can you explain that thinking on why that's vital?
Yeah, so it goes back to that piece of paper thing we said at the start. It's partly about the double spend problem. It's about recognizing that now technology can emulate in digital form what we've always taken for granted in terms of possessibility. So it was only relatively recently, to go back to your question about why has this only come up recently, is that digital assets just simply haven't been able to do that until relatively recently. You couldn't have something in digital form that you used in the same way, that you expected to be singular, that you expected to be exclusive. Like Word documents. yes, we all use those, but actually the beauty of a Word document is that it's not singular, and you
Everyone
want to be
can
able to
contribute.
you want to be able to share it. But when it's a Bitcoin, you don't. You want that to be just yours, or fraction of a Bitcoin, whatever. And so what's really important about the independence thing is that, and this links back to the information question, what we didn't want to do, because it wouldn't have been right, is to say that all intangible things should have the same property rights as tangible things, because that would have been
that's casting net too wide, doesn't it?
Yeah, far too wide. Far too wide.
Things that shouldn't fall into the category. Yeah,
so those indicia, I think we called them in that paper. Did we? Characteristics. Anyway, those characteristics.
They were criteria, I think.
Criteria, okay. So those criteria were our attempt to identify and crystallise what it is about conventional tangible assets that make them the proper object of property rights, and how they therefore differ from the things we talked about earlier, intangible rights like debt. We were trying to isolate the physical characteristics that separated those two things.
And the last point on that criteria that I read out before was this whole idea about rivalrousness. The example given at paragraph 5, spot 48 was, and I quote, was Matt Kimber in charge of this, by the way? And I quote, this means that the thing in question must be something whose capacity for use is not limited. People must therefore compete with one another for it. More formally, a resource is rivalrous if use of the resource by another person necessarily, it's not easy to say this, prejudices the ability of others to make equivalent use of the same thing. Yeah. This is where I think this was Matt for sure. For example, if Alice uses a Game Boy to play her Pokemon Red game, Bob cannot use the same Game Boy at the same time. Alice's use of the Game Boy prejudices Bob's ability to use it. End quote. My question here was, why was this provision included? And I think the answer is, you've already come up with, is that you want an exclusivity to these pieces of property, right? That's the point. You can't have, it's almost like an MP3 back in the day where people copy paste and all of a sudden everybody's got a copy of this song, right? It has to be a level of rivalrousness. I guess there's nothing more to add on that point.
No, I don't think so. It is really about if it's, if something isn't rivalrous, you probably don't really most of the time need or want it protected anyway.
I suppose so,
because
yeah.
Because
you don't mind, yeah, I suppose so. All of these propositions relate to digital assets, which includes digital files and records, email accounts, and in-game assets, I think, was also included in this paper. Domain names and, of course, crypto tokens. Does this mean, then, that prior to this paper, or prior to at least some good thought on this topic, that an MP3 file wasn't property?
Yeah, probably. What we were very clear about, so this was where we had some of the most interesting disagreement, I think. We had a few roundtables where we discussed pretty much the list that you've just read out there. What we decided would be the best way to proceed, and again, this links to what I've just said about not wanting to make intangibles in general the object of these property rights, is we didn't want to isolate specific categories and say all MP3s or all digital files or all databases will or will not be, because again, we don't know how those things are going to develop in the near future, and we didn't want to prejudge, I suppose, what they would look like. So the short answer to your question is, I think, yes. And the way we wanted to get around that was to produce these characteristics so that people would at least have a frame of reference in the future to hold their thing up against and decide whether or not they would have property rights in it. I mean, obviously, you're most likely to do that through a legal advisor, but the point remains. And also, it depends a lot on context, because, of course, there is... Well, I'm saying, of course, because I've encountered it so much. Maybe listeners won't be quite so familiar with it, but I've certainly encountered a lot of homogenization of digital assets. So when you talk to people about digital assets, they just say, oh, digital assets are X, digital assets are Y. And of course, you can no more say that about them really than conventional assets, because it depends so much on the context in which they're used, on the contracts in relation to them. A lot of it is about function and context. And you can have NFTs that are rivalrous and independent. There might be another situation where they're designed not to be. So what we said was, we're not going to refer to these separate categories of things. We're going to stick to characteristics. And as long as something exhibits those characteristics, doesn't matter what it's called, doesn't matter what category it goes in, it can be the object of property rights.
And then this moves us to the next paper. So after that, there was the Law Commission's Digital Assets Final Report, 28th of June, 2023. I hope I've got that right. 2023.
Yeah, sounds about right. Yeah.
Flown by.
It was busy,
Which broadly follows the proposals laid out in its predecessor, except those three criteria became indicia, right? That's true. However, one limb, which read, and that was the first one, composed of data, you got rid of the composed of data bit. So I'll read out the quote just to make it easy. It is composed of data represented in an electronic medium, including in the form of computer code, electronic, digital, or analog signals. Why did you get rid of the composed of data bit?
So that was the result of consultation. So this is a nice example of how Law Commission consultations are genuine consultations. We quite often change our minds when we speak to all the people I've mentioned before, end users and legal advisors and so on. So there were two reasons for that, really. I never liked it anyway, I have to say. Personally, I never thought that we needed to restrict it to data objects, because I thought that the independence and rivalrous were the real key to identifying those things that need these proprietary protections. And the other point that we use in there, I don't know if you've got it written down, is because they can be, and again, it's a bit of a mouthful, involuntarily alienated, which means that as a matter of fact, they can be taken from you. So I can take your car if I get your car key. So I'm talking factually, not legally. Right. So factually, I can take your car, I can take your watch, I can take your things away from you if you don't, even if you don't want me to. Can't do that with a debt. I can't take your rights away from you. I can infringe them, but I don't remove them from you. You still get them. You still get to keep them. Digital assets, or the sorts of digital assets that can be the object of property rights, need to be those that can be involuntarily alienated, which is why they're rivalrous, why we care that we want them back. And I thought that independence and rivalrousness were the only things we needed to make that identification. And then when we were speaking in consultation with various groups, so for instance, they brought the same thing to our attention. So for instance, there were people who talked to us about voluntary carbon credits. So,
I saw that and thought that was a bit of a left field thing to include, but I wouldn't have thought about it. It's a good thing to include.
Yeah,
right?
really good thing to include, and potentially massive, and obviously growing. So these are, credits by which you can offset your carbon contribution. They're obviously very valuable. They're tradable. I think they're the thing that actually sits closest to the border of our, our criteria. But we saw no reason, particularly once we were presented with the arguments from those who thought that VCCs should be the objects of property rights. And there is at least one case where they are involuntarily alienated. I can't think of a snappier way to say that.
You're doing a better job than me with saying these hard words.
Well, I've said it so many times. So we got rid of the first limb. And I personally think it is so much better
without
right
that. Decision.
Yeah.
So one point that runs through this paper is the recommendation to let common law develop the jurisprudence in the area, i.e. not to legislate, but allow the courts to figure this out as and when those questions arise. Surely this approach puts extra pressure on judges and means the only way these issues are determined is where, number one, there is a dispute between parties, and two, where there are people who are wealthy enough to pay lawyers to figure it out, which is on the most part rare. I've had personal experiences that have been really interesting, but people don't really want to spend money finding out what's academically interesting. They want their rights, they want their property, whatever it may be. I appreciate that we are now, as we sit here today, at a legislative level, but given that this was last year and that the general sense of things was that it should be common law led, how do you marry this up with the resulting proposition?
The resulting proposition, you mean the bill?
Yeah.
So this is another interesting insight into Law Commission process. So for the reasons that we've already talked about in this podcast, we thought common law was far better suited because it can be more responsive. You can future-proof the whole thing, because as soon as you start saying, in statutory form, what is a digital asset?
It's out of date before you've started. Right?
Yeah, exactly. So we thought That's incredibly difficult. Some jurisdictions in the world have tried it, and those the resulting statutes have run to thousands and thousands of provisions. And of course, once you start doing that, there are more hostages to fortune. So a lot of people, usually non-lawyers, think that a statute equals less uncertainty. Of course, once you're a lawyer, that's not strictly true. So the courts still have to interpret them. So we thought, well, common law is the best way to do it. And common law has dealt with property so well for centuries that really what we wanted to do was just sort of sneak digital assets. Probably shouldn't say sneak because that makes it sound underhand. We thought we should just sort of key digital assets into the development of the common law and let the common law do its magic. But the whole point of our final report that you just referred to was that we wanted to be able to, because it is absolutely a bit of what could be seen, I suppose, as passing the buck to judges, and it's a big job for them. So what we said is, well, we'll do this final report that will provide the analytical framework that judges can refer to, and thankfully it has been used in that way. But the interesting thing was, we had this round table with judges, as we do with all of these things, and obviously we clearly wanted to bring to their attention the fact that we were about to go, there you are. I think it's all over.
Enjoy, off you go.
Yeah. Go and read this. And they said, I mean, we did sort of suggest it, but we didn't think they'd go for it. But they said they would actually find it very helpful to have the report, but also to have a very small statutory, and this was their words, unlocking provision that just made it absolutely clear that in law, a digital asset could be the object of property rights, even though it didn't fit into the two categories that I mentioned at the very beginning of the podcast, thing in possession, thing in action. And they said that's all they need just to open it up, because this is actually a very big legal step to go from those two categories that have been there for centuries. Yeah. And they said they'd just find it really helpful. So we've actually got that little bill, which was introduced to Parliament 2 weeks ago, because the judges asked for it. So they were quite happy to develop the common law alongside our guidelines. And I should make it clear, they are absolutely guidelines. We are, of course, not telling the judiciary what to do. We couldn't do that.
But they just needed that little bit of the door kicked open slightly so that they could then make law. Yeah. So I guess my question was probably quite unfair then, because actually now that I've learned why the bill is drafted as it is, it's the judges saying we're happy to make the law, but help us out. Give us that little bit extra to direct the law in the right way. The fundamentals done.
Yeah. It was almost like permission, really. And I use that word as something that was discussed at that round table because Parliament, of course, can give the judges permission, and we make recommendations, and then Parliament does it. Yeah. So if and when this bill passes, it will be Parliament saying to the judges, yes, go and do it. Go and do this thing.
And that's it. I guess it's that open door to just give them the ability to go and create law in the way that you anticipate.
Yeah.
The latest report, and I suppose the final report, published 22 July 2024, and was a supplemental report and a draft bill for Parliament, as we've just spoken about. A short note I put in my notes here, that in the previous paper, the three criteria then became indicia. I can't say it.
Indicia.
I don't think I've ever had to say it aloud before. Indicia. So it didn't mean that each of them had to be followed by the strict letter law. It was something that was proposed. A paragraph of this supplemental paper at paragraph 3, spot 32, notes a thing will fall within a category if, quote, it is functionally analogous to those things that attract property rights and is itself capable of attracting property rights. And 2, is not comfortably either a thing in possession or thing in chose, which is as you've described. I understand that there's some future-proofing here. I've used that term throughout this recording with you. And it's not to limit the definition of things which exist now, but to, as I say, future-proof things going forward. Is there anything that is on the horizon already that you've seen, that you've thought, oh, I'm so glad we left this negative definition open? Or are we still in a period whereby we are waiting for these new digital assets to exist?
I think there's no sort of discrete category that I can think of at the moment. Maybe that's not so surprising given that we're less than a year down the road. But what I would say is there are two things. So VCCs that we've already mentioned, they are, so voluntary carbon credits, they are evolving. Their form is evolving. And what I've seen even since the report, not the supplemental one, the one before that, is the massive increase in real-world asset tokenization and uptake from major banks, most of the major.
This is the trendy thing this year, isn't it? It's tokenization of real-world assets.
Yeah, absolutely.
So, before was NFTs. What's next year?
Yeah, exactly that. So, although we did have those things in mind when we wrote those recommendations, we didn't. And did we anticipate? We didn't know. We didn't know quite how big they were going to get and how quickly. And of course, the bigger they get and the more adopted they are, the more refined the technology will get. So yes, I am increasingly pleased that we were so, raw with our description of what was necessary, and we didn't try and define in any more detail what we meant by a digital asset, because I honestly think that in 18 months, we will be seeing digital assets that don't look anything like the ones that we see now. So,
in fact, the draft bill is called the Property, Digital Assets, etc. Bill. The etc. I thought was quite interesting, but let's not talk about that. Slated for Parliament on the 11th of September 2024. The words digital and electronic are included only as a reference, and I think you've gone through the reasons why. The wording of the bill reads, and I quote, "A thing, including a thing that is digital or electronic in nature, is not prevented from being the object of personal property rights merely because it is neither a thing in possession or a thing in chose." The subject of the bill, however, is a thing. Is that the right word? It seems a bit obscure. Thing. It seems very open.
It is, deliberately so. So, when you've heard me say several times today, I'm trying to be generic. And throughout these projects, I've tried to be as generic as possible. I mean, personally, I'm not I didn't.
You don't have to take credit for the word thing.
Oh no, I don't mind taking credit for the word thing, but you've already drawn attention to the fact that it's called the Digital Assets Etc. Bill, and the first line that says a thing including a digital thing. I mean, I actually don't think those parts were necessary. I would just
the parenthesis bit, the bit where it says including a thing that is digital and electronic.
I don't. If it had been up to me, and obviously it wasn't, it was a joint effort and a consultative effort, but. If it'd been up to me, I don't think we need digital. I don't think you need to put that in. Most of the time it will be digital, but it's not a necessary. But thing, I think, is very important. So thingness.
Is that a word?
It is now. It is. No, it's not. I certainly can't take credit for that. There's a lot of property literature on that, and there's a guy called Henry Smith who writes about thingness. Okay. And thingness is what we've tried to do there with independence and rivalrousness. It's to crystallise and identify what it is about stuff that makes it the appropriate object of property rights. The things we've talked about, full divestibility on transfer, being able to hold it. And when I say hold it, I don't necessarily just mean with my hands, because of course I hold things in my wallet by other means. Control. I mean, control is key to the final report, certainly. So once I can control something, it is likely to be seen, and I hope it will be seen by the law as a thing, and I can only control things. So yes, deliberately generic, because I think all that is necessary are those characteristics, and whatever in the future might fall within those characteristics, there's no obvious reason to me, and I'm going to leave it in the negative way, there's no obvious reason to me why it shouldn't be an object of property rights. But that negative thing was suggested to us by the judges, the negative phrasing, the
judges.
But I think that's really important, because what we're saying is, again, we're not telling the courts, or Parliament, I should say, Parliament will not be telling the courts, you must say these things are objects of property rights. What they're saying is, there's no reason not to. If the facts are right, and you feel in this case like it's, so AA, if you feel that there's no reason why it shouldn't have a proprietary injunction, then feel free to do it. But there's no mandate. There's no every time a digital asset fulfills these conditions or exhibits these characteristics, it has to be the object of property rights. And I think that's really, really important, because that would take away quite a sort of safeguard, really, a legal safeguard, that if a judge thinks, or a set of judges thinks, actually this doesn't feel like it should be analogous to a property situation, then Parliament hasn't told them that they have to.
So this whole negative definition thing is really to give judges comfort that they can make decisions without looking silly.
That's exactly it, yeah.
Silly the right word?
Well, without looking unconstitutional, I think, Okay. So yeah, that's exactly it.
And I suppose it is due to be considered by Parliament. Do we know when that is?
Well, it's been introduced now. It'll be...
How long do you think it normally take?
Well,
And if the answer is we don't know, we don't know.
We don't know. It's how long is a piece of string. I mean, it's affected by how long a bill takes is affected by all sorts of things. So the Electronic Trade Documents Act.
Your baby.
Yeah, my baby was affected by the death of a monarch because Parliament dissolves. We had 4 Lord Chancellors, we had 3 Prime Ministers, we had a couple of general elections. And every time you have something like that, Parliament dissolves. So you lose the... So you can't even predict on the basis of this. It's not usually about the substance of the bill, or certainly not in the case of these, because they're not too controversial. So the short answer is very much we don't know. I suppose we could say, based on current political relative stability, it might be quicker than it would have been for, or it was for the ETDA. I mean, I would be hopeful that it would be within 6 months, but
it's only a small bit as well. I think I read it all out on this podcast.
You did. It's tiny.
Exactly,
it's
right.
tiny.
So you just
but
go,
it's about getting the time in Parliament, and
it's the timetabling, isn't it?
Yeah, it's the timetabling. So I'm afraid I really don't know.
Well, I hope it comes soon, because it'll give confidence, even more confidence to the market, which is an important thing. I'd like to talk about your new role as the head of digital assets and trade finance at D2 Legal Technology, because you've now moved on from the Law Commission. Firstly, who are D2 Legal Technology and what do they do?
So it's a really interesting set of consultants, really. And one of the things that I found fascinating when I was doing the Law Commission work was, and one of the things I really enjoyed was being a bridge between the legal world and the technological world, because increasingly now, probably more than ever, those two worlds really have to talk to one another. And I think it's still fair to say they find that very difficult, because they use different languages, and in the case of technologists, literally a different language. So there is a real disconnect often between those two worlds, which isn't helpful. So at the Law Commission, we tried to do that. We had a few very techie lawyers who could do that. And then once we'd done these law reforms, I felt like the job wasn't really finished, because of course you can change the law and you can make the conditions quite conducive to people to adopt new technologies, but that doesn't necessarily mean they'll do it. There's always an implementation difficulty. So what D2LT can do is be that bridge. And it deals with both practical implementation, whether it's documentation, whether it's digital assets, whether it's AI, and the legal side of it, and sort of meshes those two things together, which we found is, really helpful and what a lot of clients want, because you can produce a legal memo or a piece of, legal advice, and then it can just sit there, and it's there, but either nobody knows what to do with it, or nobody notices that nobody notices they have to do something.
But it's sitting in a drawer.
Exactly. And the people who understand that legal advice are not the people who understand how to implement the processes. So that's what we do. We fill that gap.
And what does your role entail, and how does your experience as a professor and with the Law Society help with that role?
Well, my role at the moment is a lot of learning. So I sit around listening to people thinking, I must remember that. So a lot of what I've just said, which fits in really well with both of my previous roles, actually, because obviously as a law professor, you have to teach some pretty complicated ideas to, well, at least in the first instance, people who have no idea whatsoever about law. And you have to do that in quite a short amount of time. And then, fast forward to Law Commission days, and it was even harder, because what I was doing was trying to we had to sell these projects to government, trying to sell these really quite complex law projects to people in government who weren't lawyers and had about 20 minutes. And were interested in, what's going to look shiny, what the minister's going to like, what will look good in the papers. And when you're trying to say, well, we want to reform the Bills of Exchange Act 1883 because, and you can see that, the
blood drains from their face,
exactly.
Yeah.
So you have to develop ways of, and you can usually do it through money as soon as you start talking figures. This could save us $224 billion a year.
There's clearly more of a story there.
Yeah, so you just have to learn ways to get your point across, understanding that not everybody is the legal geek that you are.
That's what I'm trying to do on this podcast, trying to help people understand, number one, digital assets and tech and law to some extent. A question that I sometimes ask, nice and broad, is what is your view of the future of digital assets?
Well, I've been optimistic all the way through these projects. You know, I've always said to people, we're not just looking for problems. These digital assets are being used more and more and more. I think it's exponential. And so we are going to encounter more of these issues, which I see as a good thing, because that's the way that you iron out problems. And that, I think I've been proved right. I don't mean to suggest that I was the only person saying that, far from it. So I think we have been proved right, the people who said that. And I think they are going from strength to strength. So definitely in the past 3 years, I spent a lot of time on the conference circuit, practitioners conference circuit. And the conversations I've heard over those 3 years have come on leaps and bounds in terms of, real use cases. As I said, big banks, JP Morgan, embracing digital assets, using them an awful lot. It's not just we might do this in the future. It's this,
they're actually implementing.
Oh, absolutely, yeah. And of course, every time that happens, you get then more impetus for developers to make them better. So, exponential is what I see the development as.
And I'm going to ask you a final question that I haven't included on the piece of paper. I've just thought about it now while I was listening to you. Is the UK the leader in this, or do you feel like there's somewhere else doing a better job at encouraging the use of digital assets?
I think we have been a leader in a lot of ways, and certainly in terms of private law rights, which is essentially what you and I have been talking about today. I think we are a leader. We had our Law Commission work cited in the Celsius bankruptcy case in the US because the judge there didn't have any other thing to refer to. So that was quite nice that we, because that's exactly what we wanted to do. We weren't precious about it. We wanted to send that out. So I think in terms of private law development, so Dubai has recently done quite a lot of work, but based on what we've done as well. Singapore is always a front runner, so they certainly did electronic trade documents before we did, because they're a bit more of a nimble legal system and a parliamentary system. So in the private law context, I think we are a leader, actually, and we're certainly in the vanguard. I think the other question, of course, is regulation, because you can private law, you can agree things under private law all you like, but if you're then regulated out of doing so, then it's no good. And regulation-wise, I think we're sort of in the middle, really. We haven't been incredibly, we haven't been incredibly restrictive in the way that the US SEC could have been said to be until quite recently, has, I think, moved.
It's gone one side.
Yeah. But equally, we haven't rolled out the red carpet, and we were never going to do that. It's not a very English jurisdictional thing to do. And I think at the moment we're waiting and seeing, which isn't a terrible thing, because I don't think there's necessarily a first mover advantage. So in regulation, I think it's a bit more of a wait and see. But I'm quite pleased that I think we have been at the forefront of the other developments.
I think we've done a good job in this jurisdiction. I think for my world, private law, being in the High Court, there's been decent amounts of precedents. And when I speak to certainly American lawyers, they're always relying on SEC type cases, and it's just a whole different ballgame. And when I tell them the type of work that I do, they seem to be semi-flummoxed that you can do this sort of thing in this jurisdiction.
Yeah.
So I think we have an ability to be a little bit more nimble than others. But my sense of regulation is that we haven't been particularly knee-jerk, but we have been maybe too patient. But I think that sort of agrees with
I think
we're in the middle.
We've been too patient. Yeah,
I think we're being too patient.
I do. I think it's about time now that. But I say that, and that there are there are things being done. It's not as if at all.
No one's sitting on their hands, are they?
No, they're absolutely not sitting on their hands, no. And it's better not to rush into these things. And, you do need to get the private law sorted before you can do the regulation, because, of course, you don't know what you're regulating if you don't know what the legal... So I think it will be fine. Again, this optimist in me. And I know that, for instance, the FCA is definitely on it. So we will see.
Okay, well, thank you very much for joining.
That's a pleasure.
Thank you.